This is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. Go ahead and put your questions in the comments. I have a good topic today. I'm going to be talking about getting the green card while being in the U.S. That's where you're physically in the United States and you want to be able to stay here and get the green card. Now, this is a very broad topic. So, there are different ways to do this through adjustment of status, and different people are going to qualify to get the green card in while being in the US based on their particular circumstances. So, I'm going to focus on the general requirements of adjustment of status, and then you can always follow up with your questions, but keep in mind that this is not personalized legal advice. If you really want to get started on your process, the way that you're going to do this is to make sure that you schedule an appointment so that we can evaluate what your situation is and move forward with your process should you qualify. So the consultation is going to be where you're going to start. So adjustment of status is what you're going to apply for when you are in the United States and you want to get permanent residence. Now, you of course do have to qualify, and there are different ways to qualify through an employer. And when you're doing it through an employer, you usually have to be applying for it at the same time that you're already in legal status, and you have to make sure that you meet the qualifications for whatever employment based position you're applying for. So for example, if you're doing the national interest waiver, that's where you have exceptional ability or you have an advanced degree, then you're going to be able to apply based on showing that you have those qualifications along with the adjustment of status application, and you have to be in status. So maybe you're here on a visa, maybe you're here on another employment based temporary visa like an H-1B or an O-1. And if that is the case, you can then adjust status as long as you don't let your status expire. And then if it's not, the national interest waiver does not require you to do a labor certification. You basically ask them to waive that. That's why it's called the national interest waiver. Uh, no, but if it's another type of position, say it's a permanent position with an employer, but say they're sponsoring you as a secretary then, or as a truck driver, in that case, you would have to go through the labor certification process. And that means that you're going to have to first go through the Department of Labor. And then once you go through those stages, then the next step is to go through the adjustment of status. Your timing has to be right though, because you can't go through the labor certification and then when that is finished, you're out of status and then apply. You have to maintain status for the entire time that this process is going forward, the labor certification, along with the actual filing of the adjustment of status application. Then there's family based. Family is going to depend. So I'm going to give you two scenarios with family. Let's start with you're here on a visa. Say your family member filed for you years ago, and then you got notification that the National Visa Center was ready to start processing your application because your priority date is now current. In this case, if you find yourself in the United States at the same time that your priority date becomes current, you're in luck, because that means that you can then file your adjustment of status application and finish out your process here in the US. You know, this usually occurs when you're waiting for your priority date to be current. This usually occurs in situations where the filing is longer. So if a parent is applying for you and you're 21 or over, or a sibling is applying for you and you have your visa and you end up in the US at the same time that your priority date becomes current, then adjustment of status could be the process for you. Now, what if you're out of status, though? If you're out of status here in the US, there are only limited individuals that can then file for adjustment of status while being out of status. And this is where you are the spouse, you're the immediate relative of a US citizen. That means that you are the spouse of a citizen, you're the son or daughter of a US citizen, and you're under 21 and unmarried, or you're the parent of a US citizen and that US citizen is age 21 or older. In these cases, in this family-based case, where you are the immediate relative of a US citizen, then you can go ahead and file even if you've overstayed your visa. It's a different story if you came into the country without permission, so you crossed the border without permission, or you were not paroled, then it would be a different situation. There are ways to finish out and get the permanent residence, but it likely won't be through this adjustment of status. And remember, I'm reminding you here that adjustment of status is the process of staying in the US and applying for permanent residence. Now, the exception here is even if you cross the border without permission, even if you overstayed your visa, you may be able to qualify for adjustment of status if you're applying for VAWA. This is why I talk about VAWA so much, because it is a potential solution for many individuals who don't realize that they have this eligibility. If you have been mistreated by a US citizen or legal permanent resident spouse, a parent, or an adult child who's 21 and over, a citizen adult child who's 21 and over, then this could be for you, where you could apply even if you cross the border without permission and even if you overstayed. This could create a pathway for you to be able to get a special VAWA status and then move on to getting permanent residence in the United States. So it's an important form of relief. Then there are two others that you may be entitled to get in and still get a path to permanent residence if you're out of status, or you have crossed the border without permission, you've overstayed. And this is if you've been the victim of trafficking and if you have been the victim of certain crime. Now, as the victim of trafficking, here's my rule of thumb. If everything you know about trafficking, get that out of your head. And I know if this is the first time you're listening to me, or the first time that you're listening to me talking about trafficking, you may have this picture in your head that trafficking is where someone is kidnapped. They're coming out of the grocery store and someone puts some chloroform over their nose and puts them to sleep and kidnaps them, and they wake up in a basement somewhere, being halfway to Mexico, or they're being crossed over state lines and sold to do acts against their will. That happens, and that is a form of trafficking for sure. However, trafficking comes in different shapes and forms. And trafficking on a whole involves labor situations. It involves intimate partner relationships. It involves relatives and acquaintances. It's my rule of thumb is, if you are in a situation, and whether it's an employer, whether it's a relative, whether it's an acquaintance, whether it's an intimate partner, you don't want to be in that situation, but you're feeling like you have to stay in the situation because this person is manipulating you. They are telling you that ICE will get you, they'll get you deported if you don't do what they want you to do, whether it is to do sex acts, or whether it is to do things like cleaning the house, or to work for their company, or to do little tasks for them personally. If they are doing this to you, that and making you feel like you're trapped in the situation, you have to stay, this is a form of trafficking. It could fall under labor trafficking, or it could fall under sex trafficking, depending on what kind of relationship you have. If you have a relationship with the employer and it's labor, but the employer is telling you if you leave the job, they're going to call ICE, or they're not paying you, they're overworking you, they're threatening you, they're abusive towards you, they're degrading towards you, then that's a labor trafficking situation. Keep in mind, there's also relief there, even if it's not trafficking, but there are labor violations against you or you have witnessed labor violations. But that is labor trafficking, right? Where you feel forced to stay in that situation because the employer is doing acts that manipulate you into being trapped into that situation. With the intimate partner relationships, that's also can lead to trafficking and sex trafficking. Just depending on what you're forced to do. If your intimate partner, you want to leave but they're holding your paperwork, or they're threatening to call immigration on you, or they're threatening violence against you, that they'll find you if you leave them, this is a form of trafficking as well. Yes, intimate partners can turn into traffickers. Unfortunately, this does happen. And then, of course, you have those situations where the intimate partner, first they start out with you as their partner, and then they may convince you to do things like get with other people for money and or in exchange for things of value. By the way, that's another thing I want to mention here with the trafficking, is that if an employer or someone who works for the employer, it doesn't have to be the boss or the manager or the owner. If someone is working for a company and they are saying you need to do acts for them to get the job or to stay in the job, and you're an immigrant, that is also a form of trafficking. So I just want to take a little detour there to educate you about situations where you can get immigration relief. Now, should you qualify as a victim of trafficking, you can have a pathway to get permanent residence. That way, through adjustment of status, where you will be in the United States, you'll be able to stay in the United States after being approved as the victim of trafficking. And the same with the U. The U, though, it is taking 10 years, but while you're waiting those 10 years, you're able to stay here under special deferred action, meaning protected from deportation, and you're able to get your work permit and social security while you wait for your turn to get the U visa, and then you can apply for permanent residence. So asylum is also another way. So if you are in fear of returning to your country, you're here in the United States, applying for asylum is going to be one of those options that you need to explore, and you can always talk with me. You are able to get the work permit while you wait for the asylum process to be completed. Asylum is taking anywhere from 3 to 5 years, but you're able to get the work permit after 180 days after the date you've applied. And that is renewable until they have completed your asylum application. Once you've been approved for asylum, you can then adjust status after 1 year of having asylum. So I just listed in a nutshell many of the common ways that individuals can adjust status in the United States. So if any of this feels familiar, feels like, I feel like I can fit into that situation, that's where you should call and schedule a consultation, and we can talk about it. I can evaluate your facts and get started on the adjustment of status. Now, once you're here, you qualify for adjustment of status and you apply, that's where you can get the work permit and your social security number. So one of the great advantages of adjustment of status here in the United States is that you are able to get settled, get a head start on life in the US while you wait for your process to be completed. Adjustment of status tends to also be shorter than if you did consular processing, where you were outside of the US and you are applying to come into the US. My shortest is 5 months, and it tends to be anywhere from 5 months to a year and a half for adjustment of status. It could go longer, by the way, depending on what the particular situation is. But my experience as an attorney is that that's the general timeline that the cases take. And with the consular processing, it takes about 2 years. All right, so that's what I have, information I have about getting your green card while being in the United States. This is not something where you can come here and just apply. You have to qualify, and this is where you should get in touch with me. Let's talk about what your particular facts are and determine whether you fall into any of those categories to get you on track to gaining permanent residence in the United States. And in the meantime, your work permit and social security number. All right, so now I'm going to answer questions, and I see a couple coming in, so I'm going to answer. So, hi there, good afternoon. Um, So I submitted documents for immigration 1 year ago, didn't hear anything from them almost 1 year ago. So that may not be unusual, just depending on the type of application that you submitted. You really have to look at the processing times, and you should check on the USCIS website to see what the processing times are for your particular case type, which I see I-130. So a year is about the average time that a decision has been made. But if they're not asking for anything right now, you should just wait on that decision. All right, so let's go. I'm looking out for questions. So go ahead and put your questions in the comments, and I will answer. How long after you receive a green card can you apply for a child? Right away. There's no wait period. Okay, so can I get a driver's license in the state of Florida while waiting on adjustment? Can I use the I-130 approval to get it? No. So the I-130 approval will not get you the ability to apply for the driver's license. Usually what does is if you can show that you have legal status, current legal status, or if you have your work permit and your social security number. If someone puts on the I-94, they're a citizen, is it not the chance to adjust status for them? So that, yes, if they put, that is a serious, serious offense under immigration law. That is as one of as serious as it can get. It's a permanent bar from getting permanent residence and citizenship to falsely claim U.S. citizenship. And yes, that could be anywhere. If you claim false citizenship on your I-9, those are employment documents. If you claim U.S. citizenship on your taxes, if you claim U.S. citizenship to the immigration, that will permanently bar you. There are ways to get waivers, limited waivers under certain circumstances. For example, in the case where maybe you grew up here in the US from you were a child and you didn't know you were not a citizen, or if you applied for asylum, that could be one way to get around false claim to citizenship. But outside of those types of waivers, you would not be able to bypass that. If my US citizen spouse first name is not on his birth certificate, can he still use his birth certificate with his state ID to file I-130? What's the cost for a consultation? So the use of specific documents, I wouldn't be able to advise here just because that's very specific, and I myself have to review each of the documents my clients are submitting to me to make sure they're acceptable as proof of citizenship. The consultation is $150 for up to an hour, so you can always go ahead, give us a call so we can represent you through your process. Can a green card spouse file for a spouse? Absolutely, yes. Now, if you are here in the United States and you're out of status, then the spouse can sponsor the spouse who's out of status, but you're going to have to go through consular processing. And then if you're out of status here and you've accrued unlawful presence, then you're going to be looking at applying for an unlawful presence waiver to be able to get forgiveness for the overstay. So it's a little more complex than a US citizen applying for their spouse who's out of status. Now, if you're the spouse of a US resident and you're here on your visitor's visa, then and you apply for adjustment of status, then that is acceptable. However, you have to also keep in mind that you don't want to run afoul of your visa rules and you know have the appearance that you when you are coming into the country with your visitor's visa, you had the intention of applying for permanent residence. There is a presumption that if you get married, if you work, or if you submit paperwork, adjustment of status paperwork within 90 days of your entry with a visa, that you had immigrant intent at the time you are walking into the country, and that can make your matter a messy situation. It's called the 90-day rule. So timing is everything with these. When you're the spouse of a permanent resident and you want to stay here to apply, that definitely that can work. And I have worked on those, but you have to just take all the things into consideration to make sure that it's going to be right for you. All right. Keep putting those questions in the comments. I am keeping an eye on the comments. What I'll tell you now is if you're ready to get started, you want to make sure that you're going about your process correctly, you need assistance and advice going forward, go ahead, go to the link in the profile. It's going to take you, and you can go to the link in the description of YouTube, the YouTube video. Click on that link, and it's going to enable you to apply to submit your information on the website, to do online chat, or to schedule your own appointment so that you know that you've gotten it from an immigration attorney and that you are equipped to move forward with your process. So, all right. I'm keeping an eye out. Now, I am going to be back on Monday as usual because I am here Mondays to Fridays between 12 and 1. Around noon is when I try to get on. So you can always look out for me at this time and I'll come with a topic. You can come with your questions and then we can go from there. So have a good weekend. And I will see you on Monday. I don't see any more questions, so I'm going to head out. All right. Have a good one. Have a good Friday. Bye bye.